Well, day 9 of the Oscar Pistorius murder trial continued to intrigue, interest and draw the attention of the whole world. And a major aspect of the Oscar Pistorius trial over the past 2 days has been the forensic evidence gathered by the police at the scene of the fatal shooting of Riva Steenkamp and the handling of that evidence in the weeks and months leading up to the trial. Now, with us in studio is William Booth, Chairperson of the Law Society's Criminal Law Committee, to give us some insights on the importance of forensic evidence and the implications of potentially contaminated evidence in a criminal trial. Always good to have you here, William. Thank you very much for coming. Let's talk about that first. I mean, how important is forensic evidence in a criminal murder trial like this one?
Well, I think it depends from trial to trial. In some cases, it can be extremely important. So that is why it's vital that when the first police officer arrives on a crime scene, that he or she makes sure the crime scene is secure. So you don't have those that arrive afterwards or members of the public walking all over potential evidence, exhibits that will later be analysed by experts, which could prove crucial in the state's case.
Yeah. Now, among other things, I mean, you speak of not securing the scene. We speak of the transportation of, let's say, the door to a specific location, how it was kept there. These are some of the issues that Advocate Barry Rue has been raising in his defence. So how important and how major are these issues?
Well, at the end of the trial, they might not be major.
Yeah.
The judge could exclude some of the evidence if she finds, for example, there's been contamination or the evidence, the exhibits, the door hasn't been properly transported from one point to the other, and hasn't been kept in a secure environment free from being damaged, for example, which looks as if it could have been. I mean, there's talk that some policeman kicked the door. So that should obviously never have taken place. And if some of the evidence is excluded, it might be important, but then again, if it might not be, because the court still has to look at the other evidence. In other words, the witnesses who heard the shouting, the witnesses who heard the gunshots. Then, of course, we also have Oscar's own testimony. Which indicates that he shot 4 times through the toilet door, even though he says that he thought it was an intruder. So the court might say, well, let's forget all the forensics. They have not been properly stored. The chain of evidence from the beginning till the end when it's analysed is problematic. But let's look at all the other evidence and still make a finding. But don't forget it's got to be beyond a reasonable doubt insofar as the guilt is concerned.
So far, what have you made of the trial in terms of the accusation, the charge of premeditated murder versus that of culpable homicide? Do you think that Oscar will be found guilty?
I think it's still early days to make that judgment, because, as I say, it's beyond reasonable doubt, and that's right at the end of the case. So you might be stuck with a criminal case where the evidence of the state is damning, but the defence evidence might cast doubt on that evidence. So the defence forensic witnesses may play a pivotal role. Or if Oscar goes and testifies and he can keep to his version, and the court can say, well, it's possible, reasonably possibly true, as the lawyers say, then maybe he could be acquitted. So you've got to look at the thing altogether. I think what's important from the state's perspective is the issue of the shouting. In other words, that it was a male and a female, which is possibly indicative that there was an argument. And then the shots were fired. That's why the defence have been trying to break down, you know, that it could have been a man shouting and not a man and a woman. The whole issue of the time sequence of the firing of the shots, the cricket bat, and the noise of a cricket bat being possibly similar to that of a gunshot. That's why the defence has been going for that angle, to throw doubt, cast doubt on the testimony of the state witnesses.
Indeed, so much that still needs to happen for us to even start developing any kind of opinion. But a question we had this morning, and we asked this on Facebook as well. Firstly, maybe you could help us define the notion of a witness being able to ask that their testimony not be televised. Does one define that as a right, as a privilege, as a luxury in terms of criminal law?
Well, in this case, the judge has made a ruling that witnesses can, in fact, decide if they wish not to have their face thrown on television and spread throughout the world. And Oscar also has can make that call if he decides to testify. So the judge has made that ruling. In terms of the Criminal Procedure Act, in certain instances, witnesses can ask that they testify in private, as it were, in camera.
Yes.
In other words, just the court officials are present and the public is excluded. Now, those certain instances, for example, if it's children, sexual offences, or if it's in the interest of state security, are but a few to mention. So there you can say, well, that type of witness in a particular case has that right.
Yeah.
Then we also have the Constitution.
Wow.
People have a right of privacy, but that right must be weighed up against the right of the public to know what's happening, and that our courts are usually open to the public. So the public have a right to know. That's got to be weighed up. But in this instance, the judge has already made a ruling as to who can decide whether they wish to be televised or not.
Mr. Booth, thank you very much. Much appreciated. We look forward to having you back again next week as we look further into the Oscar Pistorius trial. Thank you very much. William Booth, the chairperson of the Legal Committee's Law Society, or the Law Society's Criminal Law Committee. But now, that's the question we asked you today on Facebook to answer. Do you think that Oscar should be afforded that right to say that his testimony should not be televised, and it's been eliciting a whole bunch of different and differing opinions as well? So Ilana and Graham are going to be reading some of those comments for us now.
Thank you so much, Katlego. We have had or received some of your comments on our Facebook page at Expresso Show if you want to take part in the conversation. Ali Britton at this stage, she talks about it. She says Oscar is afforded the presumption of innocence and he should also enjoy the privilege like the state witnesses if he chooses. So she says, well, you know what, he should be treated like everyone else because we assume that he's innocent, and so if he chooses that it shouldn't be televised, then it shouldn't be.
And that is his right, and I suppose this all speaks to people's education in the law, which is ultimately the purpose of letting us have access to the degree that we've had. Tyrone Gavin Fester says, and I like this, short and sweet, if that is his right, then so be it.
So be it, he says.
And then we've got Thabo Moya saying, I think Oscar Pistorius himself also does not feel comfortable about his testimony being televised. What are his rights in this occasion?
I think a lot of people are asking these kind of questions because we're getting educated, as you said, watching this on TV right now. More comments coming from Expresso's show on Facebook where we asked that question. Sylvia says, I don't think the whole thing should be televised. So many murderers every day, she says, and I quote, why must this one be televised at all? She calls it sensationalism. Take part in the conversation on Facebook page live right now, Expresso Show, if you want to take part. Also on Twitter at Expresso Show.
We're going to take a very quick break. Then I've got Roger Dassar in studio joining us this morning, along with a fantastic show. So don't go too far.